Hello and welcome to the PSTN Basic Security Officer Training Series. I'm Bill Jackson. You know, the fictional detective Joe Friday has been trying to tell us the formula for a successful investigation for years. The facts, ma'am, only the facts. All too often, the importance of a thorough investigation is overlooked in the excitement and the response that happens after an incident. It is only later, when we sit down to try and sort the whole mess out, that we discover that some vital piece of information is missing. By then, it's often too late to go back to the scene and try to put it all back together. The evidence and the witnesses are gone. Your role as a security professional includes this all-important investigative function. With the information gathered at the scene and through the subsequent interview of witnesses, we can put together a plan. It is a plan that not only deals with the immediate problem of determining what happened, but also allows us to formulate the tactics needed to keep this kind of thing from happening again. The intelligence information is often more important than the causal information. So, what's the purpose of an investigation anyway? Are we just looking around to see what we can see? Should we compare the investigation to an elaborate Easter egg hunt? What are we supposed to be doing in the final analysis? Well, one of the best explanations for our mission in an investigation can be found in the words of the Association of Trial Lawyers of America. They recommend the following practices for all investigations. First, a logical sequence must be followed. That means one that can be explained in a clear and obvious way. Real physical evidence must be identified and gathered legally. The evidence that we do find must be properly stored and preserved for later use. Witnesses must be identified and properly interviewed. Leads for more information must be developed. All information that we find must be accurately and completely recorded. Those 6 guidelines open the door to a world of fascinating possibilities. Fertico's Criminal Law and Justice Dictionary defines the word investigate as follows: examine and inquire into something systematically and thoroughly. The word investigate comes from the Latin word investigare, which means to search into. What we are left with as professionals is nothing more than a quest for the truth. We're going to start from a point in time and work backwards in an attempt to answer some basic yet very important questions when we conduct a professional investigation. Our goal is simple. We need to determine what happened, when it happened, where it happened, who it happened to, and ultimately, why it happened. The initial response and the preliminary investigation are the most critical steps in the process. This is where the fact-finding either gets off to a good start or a bad one. This is when most of the evidence is destroyed if the responding investigators are not careful in their initial approach. This is where evidence can be turned into trash if we are not careful. Our initial response can best be described as a series of steps. With few exceptions, the sequence looks like this. First, arrive at the scene as quickly and safely as possible and tend to the injured. As always, people come first. Do a quick assessment of the players involved in the incident and try to locate and isolate the witnesses, complainants, victims, and possibly even the suspect. We have to keep tabs on them so that we can interview them later. Preserving the integrity of the crime scene and the evidence is critical. Once a piece of evidence has been altered or destroyed, it's gone forever. We may have to establish barriers, secure the scene, remove people from the area, and control access all at the same time. That can be a very frantic and demanding time in the investigation. The witnesses must be initially questioned about what they saw, heard, smelled, did, and any other relevant detail that we determine is a part of the questioning process. Make sure you get phone numbers in order to contact witnesses immediately if necessary. Follow-up investigators will appreciate that. We have to record all this information quickly before details are forgotten or changed by discussion with others. We also have to keep the central dispatcher informed of our activities and our needs as the investigation progresses. All of what we do and see must find its way into a preliminary report, commonly referred to as our field notes. Nothing in an investigation should be trusted to memory. There's a great deal to do in that short listing of topics. Doing them well can spell the difference between a successful investigation and a waste of time and resources. Now, once the scene has been secured and we have established control of the area, we can get down to the real business of the investigation. That is referred to as the follow-up. As a security officer, you may be the one responsible for doing the entire investigation, or you could be assigned the duty of securing the scene until the investigators arrive. The team that gets the investigation could be security specialists from the department or detectives from the local police agency. Your role will depend on a number of factors. For example, what is the context of the investigation? If it's an accident or an incident that centers on a possible violation of a company or worksite rule or regulation, then the whole investigation could be yours. If it involves a violation of the law, even a minor one, it could be turned over to a police patrol officer. What is the seriousness of the incident being investigated? If it involves a potential for a huge monetary loss to the company, it could come under the authority of an investigator from corporate headquarters. If it involves a serious crime, we could be assisting the state police or possibly even an FBI agent. What is the depth of the investigation? Can it be resolved quickly, or is it the type of incident that's going to require a great deal of time and resources to complete? Some investigations involve the use of skills and equipment that requires the assistance of highly trained professional people. We must keep the roles of the security officer and the police clearly separated in the investigation. The police are there to represent the people when a crime has occurred. We're there to represent our company or client when the incident could have a potential to cause harm to them or their interests. Our methods may serve both ends and may even be the same in some cases, but our roles can never be allowed to be at cross purposes. Now, as security practitioners, we're talking to people all the time. Conversation with others is a large part of what we do. During an investigation, we will be required to use those same people skills that serve us so well on the job in a more focused way than we normally would. We're attempting to put a whole bunch of information together in a logical way so we can determine what happened in a specific moment in time. That calls for the use of some specialized interviewing skills if we're going to do it the right way. First, be pleasant. Regardless of their status, witness, complainant, victim, etc., the person you're talking to is doing you a favor by having the conversation with you in the first place. Remember, you're not investigating the crime of the century. Be human, approachable, and easy to talk to. You'll get more information that way. Ask open-ended questions. An open-ended question is one that someone cannot answer with a yes or no. It's open-ended when they have to explain their answer to you. Don't ask them if they saw the incident. That is a yes or no response. Ask them to tell you what they saw. That's being open-ended. Also, don't be afraid of silence. If someone takes a few moments before they answer your question, don't jump in with another question right away. Give them time to think. They're dealing with an authority figure after all, and they could be nervous, frightened, embarrassed, or even confused. So wait a bit before you move on, and don't feel like you have to fill silence with noise. Now is the time to be patient. Also, use the long pause to get more information. Generally, most people will tell you more. Try to make the interview as private as you can. This can be very difficult in a busy or noisy work environment. You should find a quiet spot to question the person. They need to feel that you're listening to what they have to say and are not distracted. You may even want to tell the dispatch center that you'll be off the air for a few minutes so that you're not interrupted by the radio as well. Use a three-step method when you're taking your field notes of the interview. If you stand in front of someone with a pencil and a notepad looking like you're going to write down everything they say, you're going to intimidate them. You want it to feel more like a conversation. The three-step method works like this. First step, Let them tell you the whole story. No pen, no notepad. Just stand there and listen and nod approvingly. Encourage them to talk by saying things like, "Go on," or "I see." Don't let your face show any shock or disgust or humor about what they're telling you. Just listen attentively. Second step, when they have finished, tell them that you appreciate their candor and that they have some really great information. Then explain that you're going to have to write a report about the incident while you get your pencil and notepad out of your pocket. Ask them to tell you one more time and tell them you're going to take some notes so that you don't miss anything. When you introduce the pencil and pad in this way, it's not intimidating at all. It's just you doing your job. Since they just told you what happened, they don't feel that it's an interview anymore. They're just talking to you now. Let them tell the story again and take careful notes. You may even ask them to repeat certain parts so that you get things exactly right. Your witness has the feeling that they're in control of the interview. That's exactly what you want. Third step, when they're done, tell them that you want to make sure that you got the information right. Read them your notes. Now you're talking and they're listening. This is the time that they'll make a few corrections and possibly even a few additions when they hear the information coming from you and remember something perhaps that they'd forgotten. At the end of the three-step process, the interviewee walks away with a feeling that they've made a contribution and that you've done a professional job. You have the advantage of a thorough interview and the ability to tell others that you actually talked to the person about the incident 3 times. You have no idea how much a judge appreciates this. It adds validity and credibility to your interview. Thank the person for their help. You have to leave the door open for a possible second or even third interview. If you have a business card, make sure that they get one and always return their call as quickly as possible. Remember, interviewing is questioning with a purpose. They have the information that you need and they may not be in a real big hurry to tell you what they know. It's more than just a conversation. If you approach it with a plan in mind, it will be much more effective. Evidence can be defined as anything that tends to prove or disprove an alleged fact. The detective shows on television and the movies would have us believe that evidence is only the stuff that is used to put the bad guy in jail. That's only partially true. Evidence can also eliminate someone as a suspect. The thing that we need to remember about evidence is this: it is what it is, not what we want it to be. We also need to remember that evidence is a very fragile commodity. It is easily destroyed or altered and can never be put back the way that it once was once it's been moved. That's why the protection of evidence that is at the scene is so very important to the investigation. But in order to protect it, you have to know what it is. Basically, evidence comes to us in 3 forms: physical, circumstantial, and direct. Physical evidence consists of those things that we can study or look at from the crime scene. It can connect the perpetrator to the scene, the victim to the scene, even witnesses to the scene. It is anything physical in nature that we can analyze and study. That would include fingerprints, tool impressions, glass, hair, fibers, blood, soil, weapons, tools, and any other physical object associated with the scene. The neat aspect of physical evidence and the thing that makes it so useful in court is that it is what it is. Properly gathered and protected, we can show it to a judge or a jury in the same state that we found it. It speaks for itself in the investigation of the case. Circumstantial evidence consists of those conditions and situations associated with the scene or the incident that we can verify from an independent source. For example, it either was or wasn't raining at the time of the incident. It was or wasn't dark when the incident happened. The suspect's whereabouts either can or cannot be verified. The suspect either had or did not have access to the area. An insurance policy either was or wasn't in effect at the time of the incident. These are all examples of circumstantial evidence. The amount and type of circumstantial evidence will vary with the type of incident that you're investigating. Direct evidence is also called eyewitness testimony. Of the three types, this is the one that is the easiest to attack in a court of law. It is also the type of evidence that will disappear if we don't talk to the witnesses as soon as possible after the incident. Time will cause people to forget details. Conversations with others will alter the sequence of event. Most people do not really tell us what they saw. They tell us what they think they saw based on their own background and experience. This is why witnesses can be so easy to cross up in court. The important thing to remember about evidence is what is called the cumulative effect. One piece of evidence all by itself may not look like much to go on, but when you take all the evidence and put it together in one place, the accumulation of the facts may tell the story very clearly. A good investigator always looks for corroborative evidence or evidence which reinforces other evidence. This is one reason why no piece of evidence should be overlooked. The collection and the preservation of evidence at the incident scene are tasks rightfully left to the professionals. That does not mean that a security officer does not have a role to play in the protection of evidence. There must be evidence for the investigators to gather when they do show up. Your task is simply to protect the incident scene as best you can until they arrive. The following steps will help you to do that. First, establish the scene perimeter as quickly as you can. Once the injured have been treated and taken from the area, your focus must be on preserving the integrity of the scene. You can use a natural boundary like a fence or a wall, or you can create a boundary with barrier tape, barricades, ladders, rope. Anything that you can find can be used to keep people away from the scene. One enterprising security officer even used chairs laid down with the legs facing upward to keep people from an incident scene in a cafeteria. Use whatever works. Get the people out of the scene who do not have a right or a need to be there. Basically, that means everyone but the police or the investigators assigned to the incident. That includes supervisory staff and even administrators in some instances. Status within the company does not give anyone the right to destroy or alter evidence. Besides, police officers and judges really don't care who someone thinks they are in a situation like this. Be diplomatic, but get the people out of there. Take chronological notes about what happens at the scene and when. When did ambulances arrive? When were the police or the investigators called, and when did they get there? When did the crime scene unit arrive? When did you call your supervisor? Anything that you think has even a remote connection to the incident and the events surrounding it should be written into your notes. Assist the investigators as much as you can. If you are the first officer there, you have more information about the incident than anyone else. Make sure that you let the investigators and the police see your notes, but don't give them away. Give them copies if they need it. Be ready to assist in whatever way you can, but stay within the scope of your training and your job. At your first opportunity, sit down and write a detailed report about what happened at the scene. Don't leave anything out, and don't assume that someone else took care of recording something. Nothing happened at the scene if it's not written down. Remember that. The report is going to be the thing that draws all the evidence and all the events into one neat package for others to review. Be thorough and be accurate. When an item is identified and seized as potential evidence from an incident scene, it has the ultimate goal of being used in some type of trial or official inquiry. It's going to be used to prove or disprove an alleged fact. That means that the integrity of the piece of evidence is going to be subject to a great deal of scrutiny. If we're going to say that it represents something that could be used to put an individual in jail or dismiss someone from their job, we had better be able to prove that it has been properly safeguarded. That means that we're going to have to be able to prove that we have had control of the item from the time we seized it until the time we brought it into court. No gaps, no time periods where it was out of our control. The document used to do that is called a chain of custody. If you are the one who finds a piece of evidence, you will be required to sign it over to the investigator. The investigator will sign it over to an evidence tech. The evidence tech may sign it over to a crime lab tech. The crime lab tech may sign it back over to the investigator. The investigator may then sign the item over to an evidence custodian who will sign it into an evidence log and then place it in a vault. It may remain in the vault until the day of the trial and then be signed over from the evidence custodian to the investigator to take it to court. No gaps, no time periods where we did not know exactly where the evidence was and who had direct control over it. That's how a chain of custody is supposed to work. If we don't take the time to do these things properly, the attorney or other person who is representing the accused will find it easy to allege that the evidence has been tampered with or altered while in our control. If the judge or hearing officer is not convinced that this could not have reasonably happened, we could lose the use of that item of evidence. It doesn't take very much convincing to establish reasonable doubt. The idea of sitting in front of a judge and/or jury and giving testimony about an incident can cause the untrained person to break into a cold sweat. But if we're realistic about the job that we're doing, the possibility of having to testify in court is real and very probable. It is the natural conclusion to a successful and thorough investigation. Someone, somewhere, is going to have to look at the evidence that we have gathered and make a determination about who is responsible for causing the incident. It was the point of the whole investigation from the very beginning. Despite what you see in the media, there is no danger lurking in a courtroom. The case in question is not even yours to win or lose. Your function is the same as when you did the investigation. You're there to relay the facts to the person who must make the ultimate decision. You will not convict or exonerate, the facts will. Doing a good job in a courtroom revolves around three concepts. They are preparation, appearance, and attitude. A word of note, in many instances, you will make an appearance at a disciplinary hearing or a court hearing. Remember, the same three rules apply: preparation, appearance, and attitude. You get ready to go to court by doing your homework. That consists of doing the following things before the court date arrives. First, review your notes. Look at the information that you recorded at the scene and refresh your memory. Get back to that time and place as much as you can. Review your report. The attorneys have read it, and so has the judge. You need to reacquaint yourself with the contents of the report that you wrote. Review the other reports too. Get up to speed about the whole case so you can get a better picture of your place in it. Look at the evidence list too. You'll get a good idea about what to expect on the witness stand. Talk with the attorney representing your side. That will usually be the prosecutor for the state. Talk about potential testimony and lines of questioning. Ask questions about things that you're unsure of. Get to the courthouse early. Make sure that you're ready to go at the prescribed time. There's no excuse for being late to court. Now a word about appearance. Dress the part. If you're told to wear your uniform, make sure that it's clean and pressed. If you're told to wear civilian clothes, that means a coat and a tie for men and business-like attire for women. Don't show up for court dressed in casual clothing. It sends a message to the judge and jury that you're not taking the proceedings seriously. When called, walk into the courtroom in an erect posture and stand straight when you take the oath. Place your left hand on the Bible and make sure your right hand is raised above the shoulder, palm open and hand flat. Don't slouch or lean on anything. And when you're asked if you swear to tell the truth and the whole truth by the court officer, say, "I do," like you mean it. Take your seat in the witness chair and sit up straight. The prosecuting attorney will ask you questions first. This is called direct examination. Look at the attorney when he or she talks to you and answer the questions that they ask of you to the jury or the judge if this is a bench trial. The defense attorney will ask you questions next. This is called cross-examination. Keep the following things in mind when being cross-examined by the defense attorney. Pause briefly, about 2 seconds, before answering their questions. This gives the prosecutor time to object. If an objection is made, stop talking and wait to be asked to answer the question again. Answer the questions to the judge or the jury, not to the defense attorney. The people you are trying to convince are either the jury or the bench. Don't get angry. The attorney does not hate you. He or she is just doing their job. Never take what happens in a courtroom personally. It doesn't have anything to do with you. It's just a part of the workings of the trial. Besides, if the jury thinks that the attorney is picking on you, it makes your case stronger. If you don't understand a question, ask to have it repeated. If you still don't understand, tell the judge you don't understand. The judge will then have the defense attorney rephrase the question most of the time. If you're asked to answer a question with a yes or a no, and you can't answer the question in that manner, turn to the judge. Tell him you can't answer the question with a yes or a no, and that you have to explain your answer. Usually, the judge will tell the attorney to rephrase the question. In any event, always do what the judge tells you to do in a courtroom. Don't argue with an attorney. You'll lose that argument every time. Be polite. Call the defense attorney sir or ma'am, and always be polite, even if they're not. When you're dismissed from the witness stand, leave the courtroom. There is no need for you to stand around or sit in the back to see what happens. You'll look like a vulture, and the jury will notice. Besides, you've done your job. The rest is up to others. If you're not sure if you'll be called back, ask the prosecuting attorney if you should stay close by. They will tell you what to do. When a verdict is reached, you should not show any emotion at all. Don't look happy about a conviction or angry about an acquittal. Your function was to do just what you did. The judge or the jury heard the facts and decided the case based upon all the evidence. The case was never yours to win or lose. Always remember that. If you have the time, it's always a good idea to go to another courtroom and watch the proceedings there. If you take the time to study what goes on in the court, you'll get that much better at giving testimony when your turn comes around again. Well, that's our program on investigations. Thank you for joining us, and we'll see you next time on PSTN.